Sir, my time should run from now only.
Yes, you speak.
Let me submit before this August about the historical background of enactment of the Identification of Prisoners Act 1920. It was in fact in 1915 that the government of Bengal drew attention to two revolutionaries convicted in the Raja Bazar bomb case in Calcutta, who were most persistent in their refusal to be photographed, and as a result thereof, Government of Bengal suggested amendments to the Police Act and the Prisoners Act. And this was how the 1920 Act came into being. But it was done by the colonial rulers to suppress our liberation struggle for the freedom of our motherland. But sir, now after 75 years of independence, after so many sacrifices made by our forefathers, the present rulers have stepped further in the name of developing the criminal justice system to throttle the voice of all those who are opposed to the anti-people policies of this government. This is my first charge against this government so far this bill is concerned. Sir, there cannot be clause-by-clause discussion due to paucity of time. Only 3 hours, I don't know why. This draconian bill shall be discussed within 3 hours. Anyway, the government even does not agree to refer the bill to the select committee. The way personal and biological data intended to be collected by force, and the government desires to pass this bill by use of brute majority, is a fascist move, more oppressive than the East India Company rulers. Sir, if this bill is a foolproof of bringing the culprit to book, then why this bill was not referred to standing committee? My second charge against this government insofar this bill is concerned. No, standing committee before the introduction of the bill. Forcible collection of physical and biological samples of arrested persons under trials and those held under preventive laws and convicts are keeping the data for 75 years violate the principles of natural justice. This is my third charge against this government. Sir, the bill, sir, equality before the law and equal protection of law under Article 14 shall be a myth. If this bill is passed, there shall be denial of protection under Article 20, Clause 3 of the Constitution, which says, and I quote, "No person accused of any offence shall be compelled to be a witness against him," unquote. But Clause 6.1 of the bill prescribes inter alia for that if a person refuses to allow taking of such measurements, it shall be lawful for the police authorities or the prison officer to take such measurements in such manner as it may be prescribed. It is vague, completely vague. This is against the provisions of Article 20, Sub-Article 3 of the Constitution, and such vague and unlimited prescription has the competence to allow the head constable or the head warden to adopt even third-degree method to compel a person by physical torture for taking the measurements. This is my fourth charge. Sir, my fifth charge. The bill also poses danger of DNA profiling of certain communities or groups. Remember, everybody should remember that according to the available data, 60% of under trials in Indian jails belong to the SC, ST, OBC and minority communities. With the effective and extensive use of DNA data in cases, these communities will increasingly suffer the burden of perceived criminalism. Sir, arrested persons or under trial prisoners will be vulnerable in the absence of personal data protection law, which has been pending since 2019, as rightly pointed out by Mr. Chidambaram. The draconian provision of this bill will be considered as part of other measures enacted and implemented by the government for control and surveillance of the people, even after the ruling of the Supreme Court that right to privacy constitutes fundamental right. Therefore, this government has willfully neglected and deliberately failed to show any respect to the judgment of the apex court of the country. Sir, my next chart to this government is that what is the opinion of the scientific community? Has this government taken the opinion of the scientific community about the measurements? The scientific community has raised serious concerns about the foundational validity and the value of many of the measurements covered by this bill and the inadequacy of the legal standards used to assess them. For example, I am giving one example. There is no scientific basis for attributing uniqueness to handwriting samples, which is one of the measurements covered under the bill. Sir, the lack of clarity in the collection and usage of the measurement heightens the possibilities of misuse, particularly of biological samples and their analysis. Sir, the bill presents significant concerns of excessive delegation of legislative authority to the rule-making bodies, as well as excess delegation of power to functionaries under the bill in violation of Article 14 of the Constitution. Sir, these functionaries include police officers at the rank of head constable, magistrates, as well as prison officers. In addition, the bill creates an unreasonable classification between classes of arrestees that may be compelled to give biological samples and those who may not. Several other provisions fail to disclose any adequate determining principle at all and pose grave concerns of manifest arbitrariness. Sir, the bill also fails to meet the fourfold requirement of the doctrine of proportionality laid down in the Justice case, Puttoswamy versus Union of India case. Sir, the absence of demonstrated rational nexus between the legitimate aims of the bill and its coverage of persons who may be compelled to provide their measurements renders the bill an unsuitable means of achieving those aims. Regardless, the provisions of the bill also constitute an unnecessary and disproportionate infringement of the right of privacy. Sir, this bill has wide-ranging implications for the right to privacy, equality, and for the integrity of the investigative process. Sir, before I conclude, I would like to say what is the assessment of the scientific community. One or two bullet points. Sir, so far, clause 2, 1B of the bill is concerned. It says about different measurements. I have time left, sir.
No, you have 8 minutes.
7 minutes, so my time is 8 minutes. Sir, no scientific basis. There is no scientific basis to attribute uniqueness to an individual's writing samples. The identification by footprint impression is an imperfect science, and this alone is insufficient to connect the accused to the crime. No standards for the guiding the examination of fingerprints. Same finger can produce different fingerprints under different circumstances. Sir, no consensus exists when comparing palm impressions, and the analysis is also prone to errors with a high rate of false negativism. Authentication failure at the national level is 8.54%. So I conclude with this, that I oppose this bill, and before that I would urge upon the government to refer the bill to the select committee.
Next speaker.